lots of folks thought, okay, you're really using infringement and trademark IP law to retaliate against folks who are just trying to unionize, and come on, it's Trader Joe's United, it's got to raise fist. You even admit that they're entitled to call themselves Trader Joe's something. This is unfair. That brings us to something that I hadn't heard of before, not surprising because I'm not an employment lawyer, was the Norris-LaGuardia Act. Tell us about that.
Well, the Norris-LaGuardia Act is a federal statute that says basically federal courts cannot issue an injunction if it relates to an ongoing labor dispute between a company and a union. In theory, are not supposed to be interrupted or interfered with by the company filing, in this case, an intellectual property lawsuit.
Yeah.
So the district court accepted that argument, clearly in the context of an ongoing labor dispute. It was important to the district court that the intellectual property lawsuit was filed by Trader Joe's a mere 6 days after the union had filed an unfair labor practice within National Labor Relations Board.
Yeah.
So that closeness in time was significant for the district court. Not so much so for the Ninth Circuit Court of Appeals. It said basically, well, this is not really, looking at the history of the Norris-LaGuardia Act, is not really what the act is designed to get at.
Yeah.
So
there's a test that it has to involve or grow out of a labor dispute, and then the court said you have to look at the impact. What is the test for
well, it's not clear, and I think the Ninth Circuit didn't elaborate all that much.
Oh.
It wasn't clear whether we'll give them the benefit of the doubt and say maybe there wasn't enough there for them to make a decision, but they said based on the record that they had, they didn't agree with the district court's decision, and they remanded the case for further fact-finding. How that will play out, we don't know yet. It'll depend on what happens on remand. Usually in the labor and employment context, closeness in time is a key factor. So, it's not dispositive, because sometimes you can have things that are close in time for reasons other than retaliatory motive. But here, the union says clearly it was a retaliatory motive on the part of Trader Joe's, given that the two events happened so close together.
Yeah. It's kind of like, what do we do now? Let's see if this sticks.
Yeah, let's see if this works.
Let's throw this against the wall.
So in any event, I would imagine there will be more determination in the district court. But this is one of those unusual cases where both labor issues and intellectual property kind of come crashing together and make for a pretty interesting dispute.
Yeah, no, I was really happy to see it because, as I say to people, Doug and I work together all the time, which you wouldn't necessarily think. Like, why would the employment lawyer and the IP lawyer work together all the time? But these issues do intersect, and this is a real, very clear and timely evidence of how they can intersect.
We'll see how it goes. This will be an interesting one to follow as it moves forward.
Yep.
I like both tote bags.
Yeah. I don't have a tote bag. I guess I'm going to have to get one. But yeah.
Well, thanks, Kandis. I appreciate that.
Great to see you.
I've learned a lot, as always.
Yep. Thanks.
Cheers to you.
Cheers.